Hello and welcome back to Humanitas Academia, where I cover various aspects of college and university education. In a recent video, I discussed the Trump administration's attempted deportation of a Columbia grad student named Mahmoud Khalil, and there has been a significant update in this story since that first video. If you haven't seen that first video, I would recommend you watch it. It gives much needed context to this story. However, I will provide a brief background to catch you up. Mahmoud Khalil was a graduate student and a Palestinian activist. He came to the United States for his studies at Columbia and was an active organizer in campus protests in 2023 and 2024, supporting Palestinian rights. During the 2024 academic year, he led Columbia University's Gaza Solidarity Encampment and served as a negotiator with university officials and speaking to the press about the cause. His activism and public image made him a prominent figure in a wave of pro-Palestinian demonstrations on campus. Importantly to this story, he is a lawful U.S. permanent resident. He obtained his green card in 2024, and he is married to a U.S. citizen. Now, the deportation case, if you are unfamiliar with it, a nationwide student protest movement grew in response to the Israeli-Hamas war. And then after Trump was elected, his administration launched a new federal initiative to identify protest organizers with student visas and target them for deportation. So on March 8, 2025, the Department of Homeland Security arrested Khalil at his Columbia University apartment, claiming that his student visa had been revoked by the State Department. Just a day earlier, President Trump had himself pointed to Khalil's case as a herald of things to come, saying that Khalil was a well-known Palestinian activist and would be the first of many such detentions in his effort to curb campus anti-Israeli protests. At the same time, the Trump administration punished Columbia University by stripping it of over $400 million in federal funding, claiming that the school had failed to combat anti-Semitism on campus. Thus, Khalil's arrest came amid intense political pressure on the university, and as ICE agents began appearing near campus, the university advised students and faculty to not interfere. Since this arrest, there has been a significant amount of debate about the legality of this entire process. Recently, we have received an update on this. On April 11th, weeks after the initial detention, Khalil got his day in immigration court. The judge, Jamie Comans, immigration judge in Louisiana, ruled that the government had established clear and convincing evidence that Khalil is removable or deportable. In other words, the judge found that Khalil can be deported from the United States despite his green card and lack of any criminal charge. The legal basis for this deportation lies in the rarely used provision of the U.S. immigration law dating back to the 1950s. The Trump administration charged Khalil under the Cold War era section of the Immigration and Nationality Act that permits the deportation of any non-citizen whose presence the Secretary of State, in this case Marco Rubio, deems to have potentially serious adverse foreign policy consequences for the United States. This law was originally designed to bar communists and other ideological opponents during the 1950s, a time when officials feared subversive ideas could threaten American society. It has seldom been invoked in recent decades from my research, but the Trump administration has revived this authority to target non-American citizen protesters, arguing that even lawful permanent residents can be expelled if their activities are deemed harmful to U.S. interests. In Khalil's case, Secretary of State Marco Rubio personally intervened by issuing a 2-page memo to the immigration court, spelling out why the administration wanted Khalil removed. In this letter, Rubio does not accuse Khalil of any crime. Instead, it cites Khalil's role in campus protests, characterizing them as anti-Semitic or disruptive, and fostering a hostile environment for Jewish students. Rubio wrote that even speech or associations that are otherwise lawful can justify revoking an immigrant status if the State Department believes the person's presence has serious foreign policy repercussions. So in effect, the U.S. government argued that Khalil's outspoken criticism of Israel's actions in Gaza, and by extension the U.S. support for Israel, posed a national security or foreign policy risk. In my opinion, this is a pretty extraordinary claim. There's not really any evidence presented that Khalil had a direct impact on foreign policy, for example. But the judge, Judge Comans, agreed that the legal standard was met, and under immigration law, she had to decide if the Secretary of State had reasonable ground to believe that Khalil's presence could seriously affect U.S. foreign policy. She ruled in the government's favor and became the first to apply this foreign policy deportation power to a campus protest case. Of course, Khalil's lawyers defended his actions and stressed the importance of due process and fairness, and arguing that none of these principles were present in this trial. It is important to note here that this immigration court decision is not the final word on Khalil's fate. His legal team immediately vowed to appeal through the Immigration Systems Appeals Board. They also filed a separate federal lawsuit in New Jersey challenging the constitutionality of his detention and the use of this law. In fact, a U.S. district judge in New Jersey has already issued a temporary order barring the government from deporting Khalil for now, at least, until the First Amendment claims are considered. This means Khalil will not be put on a plane overnight, and the case is moving into a higher level of judicial scrutiny. Regardless, Judge Coleman's ruling was a pivotal moment. It signaled, at least in the view of the immigration court, that the administration can deport a legal resident for their activism. Unsurprisingly, this decision sparked outcry from civil liberties advocates, public officials, Columbia's own community, of course. Outside of the detention center, after the hearing, Khalil's attorneys and supporters stated that Mahmoud Khalil was subject to a flagrant violation of his right to a fair hearing and a weaponization of the immigration law to suppress dissent. Another of Khalil's lawyers specifically targeted Secretary Rubio's memo as a tacky Soviet-style diktat that's equal parts empty and chilling. In Khalil's legal team's view, the government's case was nothing more than punishment for Khalil's beliefs and an attempt to make an example of a prominent activist. Various other advocacy groups also had sharp criticism of the Trump administration's use of the Immigration Act and this ruling. The Foundation for Individual Rights and Expression, FIRE, a campus free speech group, stated that allowing a single government official sweeping a nearly unchecked power to pick and choose individuals to deport based on beliefs alone without alleging a single crime crosses a line that should never be crossed in a free society. Should be clear here that FIRE is often very critical of the far left and the rhetoric that the far left uses. So for them to state this, they are clearly very concerned about the implications on campus free speech, regardless of a political position. From the government side, officials have doubled down on the justification for their action. The Trump administration insists that this is about national security and the rule of law, not speech. In their view, non-citizens do not have an absolute right to engage in certain forms of protest, especially if those protests are seen as supporting hostile groups to the U.S. or its allies. For example, Homeland Security Secretary Kristi Noem defended the policy in a social media post, saying, "It is a privilege to be granted a visa to live and study in the United States of America. When you advocate for violence and terrorism, that privilege should be revoked and you should not be in this country." I personally feel that it is up to each person's personal opinion if Khalil did in fact advocate for violence and or terrorism. These are quite bold claims that should be relatively easy to prove, yet they were not. The administration has pointed out instances of extreme rhetoric at some rallies to argue that what they are targeting isn't political opinion, but instead support for terrorism. However, Khalil's supporters respond that he never advocated for violence at all, and his activities were limited to peaceful protests and criticisms of U.S. foreign policy. In Rubio's memo, Rubio did not accuse Khalil of directly promoting any terrorist organization. This discrepancy between the way the government has framed it and the facts of Khalil's behavior is fueling a significant amount of public debate. This case, of course, has significant broad implications. Mahmoud Khalil's case is not about a single graduate student anymore. It is widely seen as a test case with far-reaching implications in foreign policy, immigration law, government overreach, political activism, campus free speech, right to protest, First Amendment rights, etc. Many have stated that a climate of fear has already settled in for many international students across the country, as reports have emerged of other foreign students who participated in pro-Palestine protests being contacted by ICE officials or having their visas questioned. For Khalil, the fight continues on multiple fronts. His lawyers are preparing an appeal of Judge Coleman's ruling to the Board of Immigration Appeals, arguing that Rubio's claims are baseless. They are also advancing a federal lawsuit, which challenges the legality of his arrest and detention. For now, Khalil remains in detention in Louisiana, but the order blocking his deportation means he will stay in the U.S. at least until the higher courts weigh in. The public narrative around this case is still evolving. To the Trump administration and its supporters, this is a story of enforcing immigration law, protecting campuses from extremism, protecting American foreign policy, etc. To Khalil's supporters, it is a story of political repression, a peaceful student being made into a political prisoner for voicing dissent. For many, it raises uncomfortable questions. Would this have happened to Khalil if he wasn't an immigrant? What does this say about America's tolerance for dissent? That a grad student can be jailed and threatened with deportation for protest? And much, much more involving free speech, the rights of students, the rights of international students, etc. In summary, the case of Mahmoud Khalil highlights the collision between free speech and immigration enforcement. A judge allowing the deportation under a dormant law marks a new chapter in a post-2024 immigration crackdown. Legal experts are watching closely, and this ruling has prompted widespread condemnation from civil rights groups, but there is a broad debate taking place about the rights of immigrants to protest as they are not American citizens. As this legal battle moves forward, I expect it will serve as a significant watershed moment for how far the U.S. government can go in the name of national security and what the actual fundamental freedoms for non-citizens are. There is a broader debate taking place about how this affects American citizens as well, or if it even does, which is certainly up to personal opinion. However, I can say with certainty that the broader social and political implications of this case are likely to persist well beyond this one graduate student's personal fate, and will likely affect campus climate and U.S. policy toward international students for years to come. Stay tuned to Humanitas Academia, because I will continue to cover this story if new events unfold. Please like and share and subscribe if this information was interesting or useful to you. Thank you very much for listening. Thank you very much for listening.